Hi, I'm Ning Yap.
Hi, I'm Michelle Yap. Welcome to ToastTalk with the Yappies. After our previous episode where we talk about buying properties through trust as well as decoupling, we have received many good feedbacks from our audience with regards to the kind of topics that they would like to find out more. One of the topics that we're going to touch on today will be more on the concerns that owners may have when they start to sell their properties. With the vibrant market at the moment, Ning and I, today we're going to touch on the topics with regards to selling properties and what are the things that they need to take note of.
Yes. Today we're very blessed to have Debbie Brittany Lim, partners from Circular Law, in short CLC, to be back with us in our Toast Talk with the Yappies to share on this topic that a lot of clients are so concerned regarding their own properties. So Debbie, thank you for joining us once again. In this topic.
The questions from our audience. So Debbie, one of them is, if let's say for example today the seller sell the property, usually the 1% goes to the seller. The 4% by right goes to the CVY account that's held by the law firm. So if the seller decides that, okay, I want the 4% exercise fee to be issued to me, would that be something workable?
Yeah, definitely. In the option to purchase, you can actually choose either to this conveyancing account or they can also pay it out to the vendor directly. Yeah.
To safeguard the purchaser's interest, the monies should be put in the CVY account, but the sellers can always request that the monies be released to them. But it is, at the end of the day, ultimately up to the negotiations between both the seller and the buyer.
That's something to think about, right?
Yes. Yeah. And then of course, importantly, let's say if the buyer's option fee that they issue in cheque somehow bounced. Alright, so what is the seller's right?
There were instances that their signature was irregular. There were instances where they closed the account. There are also instances where they didn't check whether there was sufficient balance. So all these can actually happen. In that case, the seller can actually decide whether they want to still go ahead with the exercise and accept the 4%. That means the buyers will have to go and get either like a cashier's order or replace the cheque. Or otherwise, they can also choose to not go ahead with the sale and purchase anymore, and then they can go on to market the property again and sell it to somebody else.
So buyers out there, to take note, I mean, if let's say you're going to use your cheque to issue the exercise fee, ensure that firstly, your signature is consistent with the bank's record. Secondly, make sure that your checking account is still valid. And lastly, ensure that you've transferred your funds over to that particular account that's being issued. Right?
I think that's very important to take note.
Or they can just simply prepare a cashier's order to exercise. Then they don't have to worry about those three things.
The agreement, right? Usually the system calls sale of the property as is where is condition. So this is something which to a lot of people or audiences, right, they find that it's a bit like how do they determine this particular point? Is there anything that you can share with us?
Usually when you purchase a property from the resale market, it is always a standard term in the option, so they definitely shouldn't be alarmed. The clause would actually state that you're purchasing a property on an as is where is basis. Simply put, it just means that you are aware of the state and condition of the property, so they're taking the property as it is.
So that brings me to one question. For example, they take the key after completion, they enter the unit, and they found that the dining table is still there, everything is still there, and it's not in terms of the agreement in the inventory list. Okay, do they take that as is where is, or they can demand the sellers to come back and remove everything? Because supposed to buy as in terms of
vacant possession.
Usually on the option as well, it will state whether the property is being sold with vacant possession or tenancy. So if it is vacant, then all furniture must be removed.
So for clients out there, okay, if you take your key and you go in the unit and you see something that it shouldn't even be there, alright, then I think you can actually settle with the seller's agent or the sellers directly. We have actually covered quite a fair bit of the concern from some of the audience who have actually wrote in to us, and they wanted to know how this would actually assist them to make a better, or rather clarity, moving forward, what's the plan when they buy a resale unit. Thanks, Debbie, for joining us. It's been a great pleasure to have you. We know that you're really busy and we really appreciate your time. And we hope that if you have any questions, you can always directly contact CLC for advice. If not, you can always contact the Yappies. I'm Ning Yap.
I'm Michelle Yap. And do remember to subscribe to our YouTube channels for more chats like this, and we'll see you soon.